Welcome to the YouTube channel of Legally Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in today's video, let us understand market abuse and insider dealing. What are the restrictions on market abuse and insider dealing? The SEBI Prohibition of Fraudulent and Unfair Trade Practices relating to Market Regulations 2003, that is the Unfair Trade Practice Regulations, prohibit any person from using any manipulative or deceptive device for the procurement of any securities or sale of securities of a company. The Unfair Trade Practices Regulations define fraud as an act or omission or concealment in a dishonest manner in order to persuade any other person to deal in securities, whether or not for gain or loss, which may result in market abuse. Insider dealing in India is governed by the SEBI Prohibition of Insider Trading Regulations 2015, that is the Insider Trading Regulations, which lay down the framework within which insiders can communicate information and deal in securities. An insider of a company is prohibited from communicating, providing, or allowing access to any unpublished price-sensitive information relating to the company or its securities to any person, including other insiders, except where such communication is in furtherance or legitimate purposes, performance or duties, or discharge of legal obligations. An insider is also prohibited from communicating such information to any other person to enable trading in the securities of the company. The Insider Trading Regulations defines an insider as any person who is a connected person or is in possession of or has access to unpublished price-sensitive information. A connected person as a person who is or has during the 6 months before the concerned act been directly or indirectly associated with the company in any capacity, including on account of frequent communication with the company officers, any contractual fiduciary or employment relationship, being a director, officer, or an employee of the company, holding any position giving or reasonably expected to give access to unpublished price-sensitive information, including a temporary or permanent professional or business relationship with the company. Persons falling within the following categories are deemed to be connected persons unless the contrary is established: an immediate relative of a connected person, a holding company or associate company or subsidiary company, an intermediary as specified in Section 12 of the Securities and Exchange Board of India Act 1992, the SEBI Act, or an employee or director of such an intermediary, an investment company, trustee company, asset management company, or an employee or director of such a company, an official of a stock exchange or of clearing house or corporation, a member of board or trustee of a mutual fund, a member of the board of directors of the asset management company of a mutual fund or an employee of such an institution, a member of the board of directors or an employee of a public financial institution as defined in Section 2, Subclause 72 of the Companies Act, an official or an employee of a self-regulatory organization recognized or authorized by the board, a banker of the company, a concerned firm, trust, a Hindu undivided family, company or association of person in which a director of the company or his immediate relative or a banker of the company has more than 10% holding or interest. Now let us understand the penalties for market abuse or insider dealing. Under the SEBI Act, any person indulging in fraudulent and unfair trade practices relating to securities or insider trading is liable for a penalty of 250 million rupees or 3 times the profits made out of the insider trading, whichever is higher. In addition, if the person is found to have abetted, contravened, or attempted to have contravened the provisions of the SEBI Act, they can also be punished with imprisonment up to a maximum term of 10 years or with a fine of rupees 250 million or both. Under the Unfair Trade Practices Regulation, SEBI can take the following actions where it has reasonable ground to believe that its provisions have been contravened, either pending investigation or inquiry, or in completion of an investigation or inquiry: suspending trading in the securities found to be or prima facie found to be involved in fraudulent and unfair trade practices on a recognized stock exchange, restraining persons from accessing the securities market and forbidding any person associated with the security market from buying, selling, or dealing in securities, suspending from office or any office bearer of any stock exchange or self-regulatory organization, impounding and retaining the proceeds or securities in respect of any transaction that is in violation or prima facie in violation of the unfair trade practices regulations, directing an intermediary or any person associated with the securities market in any manner not to dispose of or alienate an asset forming part of the fraudulent and unfair transaction, requiring the person concerned to call on any of its employees or representatives to refrain from dealing in securities in any particular manner, prohibiting the person concerned from disposing of any of the securities acquired in contravention of the unfair trade practices regulations, directing the persons concerned to dispose of any securities acquired in contravention of unfair trade practice regulations to restore the status quo. Hope this video was informative. Thank you for watching.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.